Greetings this afternoon. Here's something that I felt it's very important to look into as we are busy contending for the faith and the right to practice religion and our faith. In the country, I'm Lucas Nkosi, and like I earlier said, communicated on my post that I would want us to look into section 22 of the Constitution now, so that we understand something there, and then in the light of the CRL's chairperson's response to the SIU report. So I felt it important for me to share these important things. Now, here's something as my point of departure that I would want us to understand as citizens, and especially Christians or people of faith, is that what we are dealing with currently, we are dealing with issues of the law, issues of the law. Yeah, and something about the law is because the law doesn't know the difference between a person of faith compared to a person who doesn't believe. If a law is to become a law of the country, the rule must apply to everybody. Now, how do we know? Now, if you can look, before we come to section 22 of the Constitution, if you can look to, let me start first in section 9 of the Constitution, so that we read what it says there, and then I'll be then reading others before we can camp on section 22. Now, bear in mind that, section 22 of the Constitution is part and parcel of chapter 2 of the Constitution. And we know that chapter 2 of the Constitution speaks of the Bill of Rights, meaning the rights that the citizens are entitled to in terms of the Constitution. Now, this Bill of Rights, or these rights that are in the Bill of Rights, they are basically human rights. These are not the rights that the state gives to individuals, but they are rights that the state must acknowledge. They must acknowledge. So they are there. And then historically, they come from the Declaration of Human Rights in 1948 of United Nations, after, on the backdrop of wars, world wars that happened, because some of these wars were religion driven, some of them were philosophically driven or politically driven. So in the sitting of the United Nations, different nations felt that let us form a League of Nations. And in that League of Nations, then they came up as well with, amongst other things, with this document that they call a Declaration of Human Rights. And now it's against that backdrop, or on the foundation of that in our Constitution we have a chapter that deals specifically with the Bill of Rights. Now on the rights that are in the Bill of Rights, something that is important there that I will want us to highlight is that in terms of the law, we have what we call two legal persons. In terms of the law, two legal persons, it's called, the law of persons. Legally speaking, we have two groups of persons, And person number one is natural persons, meaning human beings like yourselves and I. We are referred in terms of the law as natural persons. And secondly, they are what we call uh, juristic persons. Now, juristic persons are basically associations of persons. Associations of persons, and then meaning any entity which includes different people, any organization that includes different people or people are involved in. So those people, when they form that association of persons, whether it's a non-profit, association of persons, or maybe a business association of persons. But those two categories of juristic persons, meaning or associations of persons, whether it's companies or whether are non-profit organizations or generally organization, wherever people meet, to organize themselves. So that is an association of persons, and legally speaking, that collective, that group of people is referred to juristic persons. Now, when you look into, let me just start where it begins in section 7. It says the following in chapter 2 of the Constitution of South Africa, section 7. 1 says, the Bill of Rights is a cornerstone of democracy in South Africa. Meaning the cornerstone, meaning this is what all the laws and whatever that takes place within the laws or the functioning of our state, our government, it's based on the Bill of Rights. This is a government, this is a state that is based on the Bill of Rights as a foundation. And then you will see there in section 2 there, of the Constitution, where it speaks of founding provisions. And amongst the founding provisions, you will learn that now our democracy, our constitution, or our state is founded on the Bill of Rights. And the Bill of Rights, the section 7.1 says, B says, it enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. So the things that you see in the Bill of Rights, they are enshrined, for they enshrine rights of all people. All people have these rights that are in the Bill of Rights. And then the 2 of section 7.2 says the state must represent, meaning whether it's government, the executive, and everybody within this jurisdiction or this place or this country called South Africa must respect, must protect, must promote, must fulfill the rights in the Bill of Rights. So these rights in the Bill of Rights, they must be respected, they must be protected, they must be promoted, and they must be fulfilled. And then section 7.3 now speaks to the rights in the Bill of Rights are subject, to the limitations contained and referred to in section 36. Section 36 speaks of the limitation of these rights, meaning because we need boundaries. We need boundaries where rights are concerned. Otherwise, we won't have control. We won't have governance, but there are limitations there. But the first thing we need to know is is that these rights are a cornerstone of our democracy. We are where we are to make sure that we respect this, and we must make sure that we promote this, and then we protect them, this Bill of Rights, and as well as fulfill them. The state must fulfill them. Now, on the Bill of Rights, yes, we understand that they are there, and they are there. So we now, how do they apply? Meaning, in practice, how do they work? Then your Section 8 of the Constitution tells us, 8.1, greetings, fighter Lebogo, Honorable Godfrey, man of God, thank you. I'm encouraged. It's been a while interacting with you and seeing you, but that's good. We understand you are laboring. You are laboring. Now, on application, which is Section 8 of the Constitution, says the Bill of Rights applies to all law. This Bill of Rights is not exclusive or exclusively applied in different contexts. Now, here, in terms of application, we are told, where do this Bill of Rights or these human rights apply? They apply firstly to all law. Every law in this country, is subject or is governed by the Bill of Rights. It applies to all law. Secondly, it binds the legislature. The Bill of Rights, they bind the legislature. The legislature is all the parliaments we have. Your National Assembly, your NCOP, provincial legislatures and municipal legislatures. All the legislatures that are available in the country, they are bound. They are bound by the Bill of Rights or these human rights. And then, as well as number 3, the executive. The executive, meaning cabinet, meaning the president, the ministers, and the ministers. The executive, and as well as all the bodies that fall under the jurisdiction of the executive, like the police and everybody, they are bound by the Bill of Rights, meaning the Bill of Rights will guide our laws as to what should we do in following our laws, or what to do and what not to do. There are certain boundaries to tell, our laws, how far they can go and how far they should not go. And they bind, meaning parliament and legislatures at all levels of government are bound by whatever that the Bill of Rights are saying. And the other thing is the judiciary, the courts, are bound by the Bill of Rights. There's nothing that the courts should do to overstep this Bill of Rights. So the Bill of Rights carry more authority than the courts. So the courts, in however they are adjudicating their matters, they should follow the prescripts of Chapter 2 of the Bill of Rights, Chapter 2, which is the chapter about the Bill of Rights in the Constitution of our country. And lastly, the Bill of Rights binds all organs of the state. There's no anybody, any organ of the state is bound, meaning is bound to be aligned to this Bill of Rights. Now, Section 8.2 says, a provision of the Bill of Rights binds. Now, the provisions that we'll see in the Bill of Rights, they bind a natural or a juristic person. Like I said, that a natural person speaks of yourself and me. We who are human beings. We who are human beings, we are bound by the provisions of the Bill of Rights. And as well as juristic person, like I said, we are speaking to organizations, whether they are NPOs, non-profit organizations, or they are business organizations. They are bound by the Bill of Rights. So whether you're a human being or whether you are an organization, and by organization, as I said, an association of persons. It can be a business, can be an organization, whether it's an NPC, an NPO, whether an SOE, all those organizations of persons, they are all, even all the organs of the state, they are bound by the Bill of Rights, meaning the Bill of Rights applies to both human beings and organizations. And it says juristic person if, and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. Meaning, in applying this Bill of Rights, this provision will look into whether this is practical or not practical. Because there are certain rights, like for an example, the right to marry. It only applies to human beings. So there's nothing like organizations are married in the sense that human beings, get married. And we know in business or in organization, then you speak of issues like partnerships and mergers and so on. But how we define them, we don't define them like we define them for human beings. Hence, Section 8.2 speaks of now depending on, or to the extent that it is applicable, as long as it is applicable, and then by taking into account the nature of the right, the type of right it is, as to can we apply that right or not, depending on whether it's a natural or a juristic person. And even if they are juristic persons, you have to look into how far can we apply that right for a juristic person. And Section 8.3 speaks of now the courts, when applying provision of the Bill of Rights to a natural or a juristic person in terms of subsection 2. Now it gives sense to section 8.2 to say what you saw in subsection 2 of section 8, this is how we handle it. Meaning, when applying that provision, a court, in order to give effect to a right in the Bill of Rights, must apply, or if necessary, develop the common law. Yeah, those are issues of courts and so on, the language of the courts there. But you see, to give effect, meaning to make sure that those rights are fulfilled, or the court, apply those laws, whether for natural persons and whether to give those rights to juristic persons, then to give effect to those rights, then the courts must look into that. And where the law is silent, that they can develop a common law around that thing to resolve issues of these rights, so that they make sure that those rights are granted. Now, the B says, or may develop rules of common law to limit the right. Where limitations are needed, then that principle can be applied on the grounds of Section 36 of the Bill of Rights. Now, subsection 4.8.4 says a juristic person is entitled to the rights in the Bill of Rights to the extent required by the nature of the rights and the nature of that juristic person. Now, that's the key. Now, the subsections, before spoke to how this, rights should be granted to natural persons and juristic persons. But Section 8, subsection 4, says a juristic person, meaning organization of persons. They are entitled to the rights. They are entitled as well to the rights that are in the Bill of Rights, to the extent that extent required by the nature of the rights and the nature of the juristic person. Meaning, for juristic persons to experience these rights, we must first look into the nature of the rights. by nature of the rights, look into that right that a juristic person wants to have. And after we look into that, okay, a juristic person needs a right of this nature. Then the second thing we should look into is that now the nature of that juristic person. We must study the nature of that juristic person, meaning to grant that right to a juristic person after we study the nature of that juristic person. What does this say? This says that juristic persons are not the same. These associations of persons are not the same in nature. So we have to check the nature of those people, or that association of people, of persons, and then look into the kind of right that they are looking for, even when they are coming before the courts. We need to look into that. Now, once we are clear, we see the rights are for natural people and for associations of persons. And if they are to be applied, we must firstly look into whether this is a natural person, or secondly, if it's a juristic person, we need to analyze as to what is the nature. What is the nature? Because these juristic persons or associations of persons, they are not the same in nature. So we need to analyze as to what is their nature. And once we understand the kind of association of persons, then we can then determine as to can they, enjoy a particular right or not. Is it possible for them to exercise a right or not to exercise it? Now let's go to section 9. To section 9. Now, Section 9 says that it speaks to equality now. We have been told, as to the rights, and as the rights that these are the cornerstone of our democracy, that the state must. It's a must. There's no going another direction on that. The state must respect those rights. They must protect. The state must protect the rights. The state must promote those rights. They must fulfill. It's up to the state to ensure that the rights are being fulfilled, both for natural persons and juristic persons. And now, where limitations are there, then Section 36 will tell us where the limitations are. And there are qualifiers within Section 36 that tell us as to how far can the rights be exercised, how far can they be limited, how far can they be granted. So is there. So once we are clear on those two things, that they are rights, and this rights applies to both natural persons and juristic persons. Like I said, juristic persons are associations of persons, meaning it's different individuals forming an organization or forming a business, and then whether that business is an NPO or non-profit, or is whether a parastatal, or whether it is your business, in whatever form it takes. But at the end of the day, a juristic person, people are there, but those people are an association. So the organization or that association of person takes a personality of its own in terms of the law. Yeah, meaning those individuals that are there, they are not that association. That association stands on its own, but the people are there who form that association. So the law treats that as a collective, as a group. It speaks to also a group. It deals with a group. So the rights are for natural persons and groups, and then those groups that are arranged into associations of persons. Now, here's something that is crucial. Now, it says, Section 9 says, 1, Section 9, subsection 1 says, everyone is equal before the law and has the right to equal, there's the weight that follows. Everyone is equal before the law and has the right to equal protection and benefit of the law. Now, the everyone that section 9.1 is talking to, it refers to natural persons as well as juristic persons. So if I was to replace that weight, I would say natural persons, or a natural person and a juristic person, or natural persons and juristic persons are equal before the law. They are equal before the law. If it is natural persons that we are dealing with and they are before the law, now the natural persons, they are equal before the law. There's nobody, irrespective of their social status in the country, both a billionaire in the country and somebody in the streets in the country, where the law is concerned, they are equal. The same law that will apply to a person in the streets and a person in the mansion, the same law binds them. Same law binds them because they are included in everyone. Meaning, when it comes to the law, we don't check as to the status of a person. I mean, including the president. The president, in terms of the law, is as equal to each and every citizen that is in the country. The president is not, in terms of a person, he is not different than any other person, including yourself, in front of the law. And it says there that you are equal before the law, and every juristic person, meaning association of persons. Now, association of persons, examples can be churches. Churches are association of persons. And it can also mean political parties. Political parties are associations of persons. It can be businesses. A business or businesses are association of persons. Now, in terms of the law, a church, a political party, a business, in terms of the law, they are equal before the law. And the interesting one is that now they are equal and have a right. The churches, political parties, businesses, and other associations of persons, they have, they have a right to equal protection and benefit of the law. The law must protect churches. The law must protect political parties. The law must protect businesses. The law must protect every association of persons equally so. Meaning, there should not be a treatment that is given to political parties that is not given to churches or to businesses. There should not be, a situation where, other associations of persons or other religions are preferred or treated better than others. And like I said, irrespective of the status. Now, when it comes to churches, a church of 5 members and a church of 1 million members, in front of the law, they must be protected the same, equally, because they are equal before the law. And whatever a church of 1 million is enjoying in terms of the law, a church of 5 people, must enjoy the same protection. And not only the protection, as well as the benefit of the law. They must enjoy the benefit of the law. Now, subsection 2 of 9 says equality. It defines, lest we get lost. It says equality includes the full, not the half, the full and equal enjoyment of all rights. These associations of persons must enjoy the full and equal enjoyment. A church of 5 members and a church of 1,000,000 members must enjoy the full and an equal enjoyment of the rights and freedoms. One of the rights that are there is the rights to access to land. If we are to give land to a 1,000,000 seater church, that is a benefit. That is a benefit to have a site, a church site for a 1,000,000 member church. To have a church site for a 1,000,000 church site, as well for a 5-member church. Both churches, in terms of the law, they must be treated equally. They must enjoy the benefits. And obviously, now there are principles there. There are principles there involved. But the criteria must not be to say, no, we are giving a 1,000,000 seater church land because they are 1,000,000 in number. Because once that is applied, then it will be a violation of subsection 2. The same treatment a 1,000,000 member church is enjoying, a 5 member church must enjoy, because on the principle of equality before the law. This is the Constitution speaking. There's no any other law that is above the law of the Constitution. If there's a law that is saying something different from what the Constitution is saying, that law is like a junior. It's like it's invalid. It's invalid. It's invalid. Every law, every policy must take its marching orders from the Constitution. Now, the Constitution says juristic persons are equal before the law, and that equality means they must all have full and equal enjoyment of the rights, and as well as the freedoms. If we give freedom to a 1,000,000 organization of member organizations of 1,000,000 people, we must give the same, freedoms to an organization of persons of 5 people in front of the law. In front of the law. We are going somewhere with this. Now, and it says to promote, meaning to make this possible, which is line number 2 of subsection 2. It says to promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair and discrimination may be taken. It says to make this thing possible, to ensure that a 5-member church and a 1,000,000 member church both fully enjoy and both fully experience the rights and the freedoms that are enshrined in the Bill of Rights. Therefore, other measures will be taken to promote that equality, to make sure that, a 5 member church is not oppressed by a 1,000,000, member church. There should not be partiality in terms of membership. And that is where subsection 3 comes in to clarify that space, to say Now, the state, because the state is responsible to make sure that these rights are fulfilled. It says the state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race, including gender, including sex, including pregnancy, marital status, ethnic or social origin, you see, color, sexual orientation, age, disability, religion, conscience, belief, culture, and language and birth. Meaning, the state in fulfilling, in making sure that, the law is applied equally on people. Now, here are, the marching orders for the state, that the state should not discriminate based on race. They must not say because a 1 million member church belong to a particular race, that is why we must give it church side, and then against that, and then deprive this 5-member church because it belongs to another race. There must be equality, there must be fairness, and the reason of unfair discrimination should not be on the grounds of race, it should not be on the ground of gender or sex, as to whether people are male or female, pregnancy, whether they are pregnant or not, the marital status. So the state must make sure that they should not use these things to say, no, but there's no way we can give you this thing because of your race and issues like that. And sexual orientation, disability, religion, because we prefer one religion, of which this is something the state has been, having it easy and has not been fully attended to, and it needs more attention. Conscience, belief, language, or birth. And it says, subsection 4 of 9, that no persons may unfairly, no person, meaning a natural person, a juristic person, no person may unfairly discriminate directly or indirectly against anyone on one of the more grounds in terms of 3. Like, in as much as 3 was talking to the state, that the state should not do this. Now this 4 says no persons, meaning individuals, meaning natural persons, should discriminate people on those grounds, the same grounds that the state was not expected to discriminate people on. Even natural persons should not do it. Even juristic persons must not do it. And then it says now national legislation must be enacted to prevent or to prohibit unfair discrimination. Now you see there it speaks of unfair discrimination. So by inverse it says, there's fair discrimination. So the rule is there should be no unfair discrimination. Yeah, but meaning discrimination can be there. So we need qualifiers to see that is it fair or unfair discrimination. And then the courts will assist us there so that we make a determination. And as for there, the law will tell us, as to what constitute a fair or an unfair discrimination there. But if it's unfair, it should not be done. But if it's a fair discrimination, because truth be told, there is something called fair discrimination. But what the Constitution is against is unfair discrimination. Right. Now, number 5, subsection 5 says, discrimination on one or more grounds of the grounds listed in subsection 3 is unfair unless, you see, what I was talking to, it says, unless it is established that discrimination is fair. Now we have to prove if there's discrimination that we are applying, then we must say, No, we applied fair discrimination. That is why we preferred one and then instead of the other on these grounds. But there should not be unfairness. There should be equality before the law. So that is the case. Now, on that understanding that says we are equal before the law, we are the same in terms of the law, and there should not be unfair discrimination. And mind you, these are human rights, these are rights, and I'm saying some of these rights they apply to individuals or natural persons, but some of these things, although they are human rights, they apply to associations of persons, juristic persons. Those people are people as well. So if we are to deal with them as a group or as an association, we must make sure that we don't unfairly discriminate them on matters, and we apply the law in a fair manner. Now that's the foundation. That's the foundation. But like I said earlier, that what I want to zoom into, applying those principles from section 7, 8, and 9. Let's go to 22. Now, here's a provision. Remember, we must, both natural and juristic persons must enjoy the benefits and equally the protection of the law. Now, in terms of and freedoms, you remember even freedoms there. Now, section 22, it says, this is a right. It says freedom of trade, occupation, and profession. Now, there's the provision. I'm reading the provision in section 22 of the Bill of Rights. It says every citizen has the right to choose their trade, occupation, or profession freely. Every citizen has the right, every citizen has the right to choose their trade and their occupation or their profession freely, not by coercion. Nobody must force you as a citizen to choose a trade that you don't want. Nobody must force you to choose an occupation you don't want. Nobody, not the state, and the state which must make sure that it fulfills this provision. No natural person should force you. No association of persons must force you to choose your trade, your occupation, or your profession. Meaning, whatever trade that you choose to do, it's up to you. Whatever occupation you choose to do, it's up to you. Whatever profession that you choose to follow, it's up to you. You are free to do so. Now, line number 2 says, now, they call it, I hear normally your legal people, they say, yes, the proviso, meaning, yeah, they qualify of some kind. It says, the practice. Now, yes, it's free for you to choose your trade. You are free to choose your occupation. Nobody will force you. You are free to choose the profession of your liking. But here's a proviso. Here's something you must follow in following those things. It says the practice of a trade, occupation, or profession may be regulated by law. That practice, as you practice that trade, as you practice that occupation, as you practice that profession freely, freely doesn't mean loosely, you see. And it says the practice of a trade, occupation, may be regulated by law. I wish we can underline those words, may be. Now, if you can check other sections where we have read firstly, you will hear a language that speaks about a must. It's a must. It's a must. And somewhere says maybe, maybe, maybe. Because maybe means conditionally, on condition that, or when it's necessary, or when it's possible. It speaks of possibility. But must means obligatory. It means you don't have a choice but to do that. That's why it says the state must, section 7, the state must. The state doesn't have a choice but must fulfill these things. Must fulfill the provisions in the Bill of Rights. And now here, where it comes to your trade, your occupation, your profession, these things may be regulated by law. They may be regulated by law. They may be regulated by law. They may be, not they must be regulated by law. They may be. Now, here's an interesting one. On that note, we know we are in the middle of a challenge and a CRL created teacup crisis that they have just created a storm in a teacup about the need to professionalize, the religious practice or religious sector or for pastors. They are saying they are trying to professionalize it, so that why they try that, they want to control. They want to make it a must. They want to create legislation by backdoor. But let's look into that, because there's this argument that CRL is putting up, and you will hear it in the media as well, and some people who are pro what the CRL is proposing. And then myself and others who are against that proposition, we are called the pushbacks. We're the pushbacks. Why are we pushing back? We are not pushing back, for the fun of it, or as a result, or thinking that now we are just crazy or lawless and so on, as they would want the nation to believe. Now, here's something about why we are against that. This regulation, whether of the church or of pastors, however they dilly-dally, sometimes they are like this, sometimes they are like this, it depends on the kind of weather that the chairperson is on. Then it will determine her choice of words at the CRL there. But here's the reason. I'm building a case, for anti-regulation, as Dr. Shimi would call it, for anti-regulation. Yeah. Here's a case for why are we anti. Because you saw section 22 says it may be regulated by law. Why are we anti? Because some of you may not understand. What do we mean that we are anti-regulation? What are we anti-regulation against? What is it that is, what regulation are we against? We are against the regulation of the pastorate, as a profession. Whether it's a profession or a calling, but we know with us it's a calling. But however, we understand this is the language of the Constitution, so we'll just borrow their definition. But whatever they choose to call it, whether it's a trade, whether it's an occupation, whether it's a profession, depending on whatever label you choose. So why are we anti this move to regulate, the pastoral in the sense that the CRL is saying it. We are not we are not like loose cannon to say we don't want regulation at all. We don't want regulation as defined by the CRL. We are anti-CRL definition of regulation. We are anti-CRL self-regulation definition. We are, as long as it's determined by the CRL, we are against it. We are against it. Because what the CRL is proposing is equivalent to state regulation. That's why we don't want it. We don't want it. Not now, not ever. Asifuni. And we are protected by the Constitution. The Constitution says, a profession may be regulated by law. The Constitution doesn't say it must be regulated by law. It says it may be. Now, the thing here that I want to deal with, is to show you qualifiers, to show you why are we anti this regulation that is proposed by the CRL and other, people, who are for it. We are anti it on these reasons, on these constitutional reasons, so that there's clarity. Because now and then they speak alone in the media when they are called and they say, we don't know why they are anti this thing. What are they hiding? We are hiding nothing. We don't want it. And our posture to say we don't want that thing, it doesn't say we are hiding anything. They are the ones who are hiding things, because we wanted to go to Rema. They called the police on us. They even thought the police are not enough. They call private security to make sure that we don't show up, to tell them we are anti that Section 22 ad hoc committee that is unlawful. That unlawful thing. There's a legal opinion from Parliament, and I said it to the chairperson of COPTA Portfolio Committee that you are wrong. Your legal opinion from Parliament is also wrong, because they didn't read it correctly. Within that document of theirs, that legal opinion, they committed an error in the very same document, which is said to be a legal opinion from Parliament. They've committed an error, and it's because of the legal service from Parliament. They did not ask for consensus. They did not request other views to say, what do you see on this? We could have told them, at that time, after our session with the portfolio committee last time. Now, one of the people who published it on the website of Parliament, I just forgot her name. She published that on the website. I went to that link, look on that website and check how she reported our engagement with Dr. Mkhize, the chairperson of COPTA, and also the MPs in that portfolio. Now, when I saw how she wrote Section 22, it was a copy and paste, of how CRL wrote it. And I call it to her attention that hello, that is wrong. You have written that thing wrongly. Remove it. Update that thing, because the Act on Section 22 of the CRL Act, it does not put a comma between staff and or other persons. CRL added a comma where the Act of Parliament did not put it. So I said, remove that comma, because you copied it from the CRL. And fortunately, I showed him from the Act to say, this is an Act of Parliament. This is the website of Parliament. Write it like how Parliament wrote it, not how the CRL wrote it. The CRL wrote it the way it wrote it, so that it can be creative with the law to accommodate a category that the Section 22 of the CRL Act does not provide for. So it's unlawfully constituted, and we still stand there on that ground. It's unlawfully constituted. That Section 22 Committee of the CRL, it's unlawful. It's unlawfully constituted. It's bogus. It must be disbanded. Must be disbanded because it was not lawfully constituted. And even Dr. Mafaza's reasoning of why they opted for that is shallow. Because within the Act, there's provision of doing it right. They did not choose to do it right, but they wanted, because they want that the controlling powers, because that one is a puppet of, the chairperson, because I'm yet to be convinced as to whether others were party to this. We need answers, as to who's complicit, who bought into that idea of that bogus thing. Now, let's get into this. Let me show you why are we anti that regulation or anti that idea by the CRL. Reason number one. They are contending. Here's a situation. You saw that the Constitution says it may be, the practice may be regulated by law. Now, let me show you why it can be regulated by law. A religious practice, why it can be regulated by law. Let me show you why. You remember Section 36 speaks of limitations, to say, no, people can have limitations on how they practice or they enjoy their rights. Even Section 36 is not willy-nilly. There are qualifiers. And remember where it speaks of, I think it's Section 8, where it speaks of the nature. It speaks of the nature of the right. And then secondly, the nature of the juristic person. So here we are discussing that provision, of the nature, because the church and this profession as well, we must study the nature of this profession, and or this occupation or this trade, of whether it's a religious practice. Why is it impossible for it to be regulated by law? It's impossible. There's no possibility of regulating it by law as envisioned by the CRL. I will tell you what is possible within whether pastors and also churches or religions and so on, what is possible there to be regulated by law on the very same principle. Now, here's the situation. I'm saying, even if you can give the CRL a win, hypothetically, CRL gets, its win and they celebrate, hey, we got them, this pushers. We got these pushers, Nkosi, the pushers. Let's say they have what they're looking for. Let's say even the court give them that. But the courts, you've seen in section, in application of the Bill of Rights, the courts are subject to the Bill of Rights as well. So the Bill of Rights, I say maybe. So they need to qualify. They must, even the courts must be subject to this to meet the qualifiers. Otherwise, their judgment will be flawed. It says, here's the thing. Now, here's the thing why we are anti, this idea of regulating, whether it's the churches or whether it's, religious practitioners. Firstly, is because of, according to Section 15, it speaks of everyone as a freedom of religion. I'm speaking to religion currently and conscience and belief. Section 15. On the grounds of Section 15, it speaks of conscience. It speaks of belief. It speaks of religion. And Section 18 then speaks of association. Now, I told you juristic persons are, are associations of persons. So provision for associations of persons is in section 18, where it says you have a freedom to associate with whatever association you prefer. It's a matter of preference. And section 31 cements it to say these persons, it starts by saying persons who wants to be part of the associations that they prefer, they should not be stopped from associating with the people they want to associate. And even if those people are non-existent, and we want to start a new association of persons, we can study it on that provision to start. That's why political parties are started every day, because they are associations of persons. Even with elections, there's a complaint to say, hey, we no longer know how long should the ballot paper be. The ballot paper will be longer and longer and longer and longer. And you know why the ballot paper keeps being longer and longer and longer? Is because of the beliefs of the people, the consciences of the people, the preference that people have. Even within parties that subscribe to same ideology, you have diversity. Parties that are Marxist, why are they not grouped into one cluster to say we have the Marxist parties under one group, and then we have those who are capitalistic and so on under one group? Because your DA, your Actions SA, they subscribe to the same philosophy, and so are others. And your EFFs, ANCs, SACPs, and others, they subscribe to the Marxist philosophy and so on. But as well as they are there, it's worse now that even the SACP wants to stand for elections on its own. Why? They are part of the tripartite alliance. They are within the alliance of the NC, but they want to stand for elections as well. They have issues even within their alliance. And because of the constitution, they can't be stopped from standing for elections, because the constitution allows them to do so as they wish, based on their freedom of association and their conscience and beliefs. They believe to do so. So now, I'm on religion. I'm on religion and the practice of pastors, or religious practitioners. Section 15 says everybody is free, freely so. They can associate with whoever, whereas they can form, as long as, they are not committing any wrongful doing. And here's something about the law. That our people need to understand. The law is like a standard. The law is like a standard. It's like a standard. When you put a law, you can't have a law for individuals. A law must cut across. Like I've shown you, according to Section 8, that we have two categories of persons. Person number one are natural persons, and persons number two are juristic persons. Now, if the laws are to be made, to be passed in Parliament, that now regulate things, we must look in this context of church that whether these laws are for individuals or they are for juristic persons. And if there are laws that are pertaining to juristic persons, then we must say, okay, they must cut across. They must not be law for political parties and laws for churches, because in terms of the law, they are equal. They are the same. They are associations of persons. People are involved. So, whatever the law is saying to political parties, it must say to churches. Whatever the law is saying to businesses, it must say to churches. The principles must be the same. Expectations must be the same because of they are the same. But I've shown you there, I think it's subsection 5 there, where it says we must look into the nature of the right and as well as the nature of that juristic person. So in this sense, why the church? Now, here's the thing. Here's the thing there. Here's the thing. Here's the thing why it can't work. So that we can wrap up this conversation. Here's why it cannot work. And I'm giving you an example of the same sector, the Christian sector. Even now, they call it Section 22 for Christian. Now, let me zoom into for Christians and show you. Now, there are, in this country, people who call themselves Christians. And within Christians, and I've learned as well, even in Islam, within Christians, there are variations of the same faith of Christians, where people subscribe to certain things and then others subscribe to different things, and yet they call themselves Christian. Now, in a general sense, let me say this. If you need a counsel for Christians, here's the thing. For that counsel to be possible, you need a common standard. You need a common standard. If you don't have a common standard, you will not have that kind of a counsel. You need people who are subject to the same standards for them to be association of persons. Doesn't Amos 3 verse 3 says, can the two walk together unless they agree? The two people cannot associate if they don't agree. An agreement means values. It means believing, subscribing to the same beliefs and, and the same values, the same modus operandi. That's why even though the likes of your EFFs, though EFF subscribes to Marxist ideology and ANC Marxist ideology, but they differ, in how they view that position. That's why you have two. And how many breakaway parties, and then who are still, of the same ideology as the ANC, breakaway parties from the ANC. Most of our black parties, they are breakaways from the ANC. So they subscribe to that, most of them to that Marxist philosophy and so on and ideology. You see, but you see variation there. The reason is why. Is because their values, their beliefs, their modus operandi is not the same. There have been things they've been trying within the ANC and they felt like, no, ANC doesn't feel it. So they started a different party so that those who subscribe to different views then can be an association of persons, then carry out their beliefs. And there's nothing wrong with that. You see? So there must be a common standard. They must subscribe to the same thing. Now, here's a problem. The polarization of religion and those who profess to be Christian, they are so polarized. You have people who are calling themselves Christians, but they are so polarized. I'll just give you simple versions as an examples. For an example, others are saying they are Christian based on teachings of scriptures or doctrine. And there are those who call themselves Christian based on preferred classification, or self-classification preference, or political correctness. There are people, if we can take the Bible and test them doctrinally based on the Bible, who call themselves Christian. According to the Bible, they are not Christian. But we can't say within this political setup, we cannot say to them, hey, you are not Christian, even though we have a right to say so. They call themselves Christian. And this is a classification they've chosen for themselves. And that classification they've chosen for themselves is protected by the Constitution, because the Constitution says they can believe however they believe. If they believe they are Christian, then they are Christian. Why are they Christian? They are Christian because they are Christian. They are Christian because they are Christian. Whether you who believes in the Bible and you'll come with doctrine and say, hey, you are not Christian, Nina, hey, because the Bible says, hey, yes, your Bible and your doctrine may say they are not Christian, but the law of the country says, leave these people alone. If they choose to identify and call themselves Christian, we allow it. They are Christian. So it's Christian based on political correctness and preference. But you and I, who believe in the scriptures and the Bible, we know that there are churches that are called Christian in this country, which are not Christian, on the grounds of the scripture. We know there are churches in this country which do not practice your apostolic gospel type of Christianity as it was passed on to us, by the apostles. We know they practice a Christianity of their choice, a Christianity that is a mixture of, your African traditional religious beliefs, and as well as, the Bible. That's why you have Sangomas who use Bibles. That's a belief. You can't say, no, Sangoma, what are you doing with a Bible? Leave the Bible alone. And some of them will tell you, our negatwastes postola. They are Sangomas, initiated Sangomas. But they go to churches that are called Christian, and they practice ukuprofita based on the spirits, of the Sangomas, but they just do it in their uniform and using the Bible. And when you ask them, what religion are you? What belief are you? They are saying they are Christian. But you go to the Bible and check, use the standard of the scriptures. There's nothing Christian about those people. And when you challenge them, you challenge them biblically, doctrinally, you are told you are judging people. I was told, no, man, you are judging people. We know. Biblically speaking, your ZCC, they are not Christian. But that's an identity they prefer. And we cannot deny it for them. They like it. They like being called Christian. But take the Bible and let's check according to scriptures. Check the practices that are being made, are done at ZCC, and show all of them, show them to me in the practices of the apostles. You won't find them. Why? They prefer so. It's them who prefer to dress the way they are dressing. It's them who prefer, to have prescriptions that they have, even their way of prophecy, their definition and description, the way they handle it is their thing. They are protected by the constitution of this land. And the constitution says, leave them alone. This is what they prefer in their numbers. Leave them alone to do that. Yeah. People, Amazion, they do it. They are not Christian in the true sense of the scriptures. Check the practices. Check, then the practices will tell you. That's why Paul in Galatians says, if somebody comes with another gospel than the one we have received, let that person be accursed. But they prefer the label. By Tanda, label. Who are we to tell them? In terms of the constitution, they are constitutionally correct, but doctrinally wrong. You see? So, yeah, there's the problem. Now, you will find, for an example, here's a new one, because you remember section 31 says, others can form. They have a right to form, their own beliefs and religion and so on. A new belief within the Christian setup has been started. And I remember one of the bishops of the Habula Church was saying, when he was interviewed about the Habula Church, why the Habula Church, why are they doing what they are doing? And then the bishop said, no, we are doing this because there are people who are drunkards, that the churches are rejecting and so on. We said, no, as for us, no, man, come as you are. Let's have this, enjoy ourselves. Let's have our booze. Let's have our Amstel. And then when in Christian churches that we know, you will hear people when they react to a sermon saying, amen, praise the Lord. Yeah. Themselves, they will say, Amstel. Yeah. Amstel. And this. That's how they've chosen. Is their version of Christianity. Where now you have booze there. And then it's fun. And they enjoy it. They prefer it. In terms of the Constitution, that is allowed. But doctrinally speaking, according to the apostolic gospel that we have received from the apostles, the view is different. So, try it to say you are from Habula Church and come with your six-pack to an Assemblies of God church. An Assemblies of God church is Christian. And if those in Habula Church are Christian and those in Assemblies of God are Christian, then it means, what is the standard? The standard is they are Christian. Common denominator are Christian. Now, let the Habula Church people come with their six-pack, of their favorite, liquor, and come then fellowship and say, Father, we adore you, as they open, that dumpy, that can, and enjoy. Praise the Lord. Will the Assemblies of God pastors appreciate that? Will they appreciate that? Will they appreciate that? Because there in the scripture it says, do not be drunk with these things. Be drunk by the Spirit. It says, give wine to a person who's dying and somebody who's in trouble and so on. It's there. They are there in the scriptures. you know. And some judgment, if you are in a house of liquor, there's a judgment there that is pronounced by God in the scriptures. How are we going to resolve that? Let's say we have that peer review council. We have a Habula church guy on that board, and we have an Assemblies of God. What standard are we going to use? Because we don't agree. Assemblies of God does not believe in people who claim to be Christian and they are drunkards and so on. Yeah. Upengute akphuzwa uyalahla. Uyalahla. Ihabula ithi awulahli izanakho endlini. Come with that booze. And Assemblies of God says throw that thing away. So the question is, are we throwing booze away or are we bringing it in terms of practice of the religion? Are we coming? So that's polarization. Some believe in speaking in tongues, some do not. What will be the standard? Some believe in mixture. They are Christian. Some believe in, mixture with African traditional religion, and they claim to be Christian. So if it's an associate of Christian, look at that Section 22 committee. It's confusion of people who call themselves Christian, who are diagonally opposed. Try having polygamous, marriage at Rema there, and ask Pastor George to marry you and see if he will accept that. He will not. He will not. He will not accept it. He will not accept it. So what standard are we going to use? You see? Now, if you are to use the law, if you are to write a law in terms of practice of Christianity, what should be done? What should be done? Because some Christian believes in going to sangomas. Abanye baqinisa ama-pulpit from sangomas. Others don't. So siyawaqinisa from sangomas or aswaqinisi in terms of practice. What law should we, if we are to regulate the practice of Christianity? Because practice is based on philosophy, it's based on ideology, and ideology is a product of a belief system. You must have a certain belief system to practice things the certain way. You do what you do based on what you believe, because faith without action is dead. For action to happen, show me your faith and do nothing. I'll show you my faith by what I do. So your practice is a product of your faith, your belief. And your belief is a matter of your doctrine. What doctrine do you subscribe to? Because that's the one. So how are you going to do it? Now I've shown you from the faith side of things. Yeah, because Abo CRL, I've heard, even in the national dialogues there, the likes Abu Sife are saying, no, why do we have doctors? Why do we have lawyers? That old-fashioned, lousy debate. Let me show you why not religious practitioners but doctors have those regulatory bodies. Let me show you why is it possible for engineers and all these other people to have those regulatory bodies, but we are anti-regulation of religion, and religion as well as the practice of religion, or whether being pastors. Why are we anti that? Here's the thing. I've shown you. We have different value system. We have different values. There's no way Khabula Church and Assemblies of God will be on the same footing. And therefore, because we don't have a common standard of belief and so on, we cannot have a same standard of practice. It won't work. It's not possible. Yeah, I've seen even Dr. Maloma made a mistake there. He forgot that, we are evangelicals. We are evangelicals. We preach the gospel everywhere. And he is bought into that idea. We are evangelicals. We are people who are from 10 crusades. We are people of 10 crusades. We are peoples of open airs and so on. But the likes of Dr. Maloma, they are against that because they're subscribing to what the CRL is saying. So according to Section 22, no more tents, no more open airs. And no more open airs. You must have a building before you practice. You must have a building. And please, when you preach, don't recruit others. You've seen political parties. They convince other people from other political parties. A person, to be in the ANC. Now they are in MKP. You see? Why? Other people were in ANC. They are now in the EFF. Some left the EFF, went to other parties, and so on. And there's no problem about it. And the question is, why a person left the ANC and went to the EFF? It's a belief. The EFF preached the gospel of their ideology. And that man or that woman who converted to EFF, received, got converted into that. But as for people of the faith, we should not preach so that other people from other faiths, we win them. And when we win them, then Dr. Maloma says that's a problem. It's a problem statement that needs to be addressed. We are taking other people's members to ourselves, even though they are in the dark. According to our faith, they are in the dark. In as much as some political parties believe that people who are in certain political parties are in the dark. Same principle. Juristic persons in terms of the law. So other juristic persons are allowed to win other people into their belief. And we, juristic person called the church, we are not supposed to win others into where we are. We know they are not Christian. That's why we evangelize them. even though they bear the label Christian. We know they are not. So they must come to the truth, the knowledge of the truth, to come to be saved, and the knowledge of the truth. Now, why doctors? Why lawyers? Why educators? Why everybody? Now, because that's that Shalom argument. Let me tell you, this is an argument I've raised with the CRL before under the the administration of Professor Musoma, to say here's a reason why you can't compare the two. Even though you can say, we want to professionalize, this thing of pastors and so on. People must be licensed. This thing must be regulated and so on. There's no licensing this one. Mam Kaluva, there's no licensing this one. Because it's impossible to do so. If you can stopping us to show up, in those forums, so that we show you reasons, then, and stop hiding behind the media and media cameras and say, where are they? They are not telling us even now. I was with her there at Kyalami. I told her, ma'am, I'm here. Elijah is here. I am here. And because he started to say, no, there's a rumor on social media. People are saying things. I said, it's not a rumor. I am here. Give it to me. And the next thing, we are serving food. I'm like, Mama, Sawubona. She couldn't even greet me. A simple thing. I was greeting, close proximity. Serving food, a basic African thing. Sawubona, Mama. Greetings. Then the worst thing, everybody she came with from the deputy, commissioner, her deputy, her deputy. They greeted me. We had time, we sat around, fun, had a debate, a discussion, and we spoke. Everybody, the whole delegation of CRL that was there, we spoke, greeted, and so on. I greeted her. She didn't greet back. That simple thing. If she fails in that simple thing, they've censored us away. They challenged me. I did an interview at SAFM. An anchor who was busy interviewing me was challenged by the management there to retract for hosting me at SAFM for that interview. The programs manager called me to say, hey, there's a problem. And now that particular journalist, presenter was pressurized by management for having me because I have dissenting views different from the CRL. What do you call that? What do you call that? So it's a clap. But anyway, I'm showing you by evidence. We talk to these people. Yeah, and we warned them before. We are not babblers and so on. Why doctors? Now, here's the thing. Why doctors? Yeah, as I wrap up, here's the reason why. Here's the reason why. Why is regulation in other professions possible? You saw Section 22 of the Constitution says it may be regulated. Now, here's the reason why others are regulated. Why is it possible for doctors, lawyers, and other professions to be regulated, but others, may not be regulated, and others, including ourselves, who are, preachers and so on? Why is it not possible? It says, now, why is it possible for other practitioners? Is because doctors study and practice the same measurable medicine. That's why doctors can be regulated. They study the same medicine and their practice is measurable. There is no variety in eye specialists for those who are interested in being eye specialists. You cannot get a doctor from UKZN who have a different view from a doctor who studied at vets and studying an eye and tell you a different thing about an eye. So the standard in medicine is the same. They are dealing with the same content, same instruments, same protocols, because these are sciences. It's not philosophy, it's science. Science is measurable. It's not a belief system. It's not by, I believe your eye can be dealt with. If it's a cataract, in UKZN, it's still a cataract at vets. That's why a person who's been a medical student at UKZN, they can finish their studies at vets and without, being started at the beginning. To say, no, you know nothing about medicine. Let's start you the vet's way, because an eye is an eye. So is everything about medicine. It's the same thing. Medication is the same thing. So you can standardize medicine. That's why there's a qualification in medicine, which is the same. There's nothing like a doctor from vets and a doctor from Medunsa, there's Fakomakato, a doctor from UKZN. If they are doctor, their qualification is the same. Their protocols are the same. How they do things is the same. That's why they can do reviews, medical reviews, to test each other, to say, baba, yukshaile lapha. Yukshaile baba. Yukshaile. First year, yukshaile. I remember another year, we had a challenge, of one of my sisters, her child had a challenge. She has autism. I raised that matter. We went, we had a meeting online challenging Pretoria West Hospital because they mistreated that child. And we had a debate with the manager there and so on. And, the mother asked, to say, guys, tell me, do you know about autism? And mind you, it was the last day of Autism Month. And the mother asked them, they are medical people, they are nurses, and doctors, medical space at Pretoria West Hospital. She asked the question to say, guys, do you know about autism? And they said, last time we did it, we learned about it was at our nursing council, our nursing school, and so on. And they made mistakes. And one of the pastors, who's a nurse as well, was challenging them to say, I did work in that hospital, and then but whatever that you've done is wrong, and you could challenge them based on those protocols in that very hospital, in the practice, and so forth. Why? Because it's the same thing. It is the same thing. So you can standardize, you can regulate. Why is it possible to have law practices and so on? Please, if you know Mam Togo Kaluva, give her this message to say, Nkosi uti. Lawyers practice the same law. There's no lawyers from Limpopo there, University of Limpopo, the former TEF. There's no lawyer from University of Venda there. There's no lawyers from UNISA and lawyers from VETS and UCT. The difference in these law schools and so on is just that others are expensive than others are cheaper. But in terms of the practice of law, they are dealing with the same acts, they are dealing with the same legislation, they are dealing with same common law, they deal with the same case laws, they deal everything. Whether it's a judge is a lawyer who's just adjudicating. It's not different from lawyers. They are the same. It's just a lawyer. It's dealing with the same law. That's why a judge can be wrong and proven wrong by a lawyer. When a judge is out of line, a lawyer will say, hey, you are out of line, judge. And some judges, they will come in, emotionally pulling rank. I've been 50 years in this. It's not the age. It's the science of law. It's not the age that says, okay, because I have 50 years in the practice, then I'm correct. Baba. A first year practicing lawyer can put you to task with your 50 years because you missed something in your interpretation and application of the same content called law. So it's easy to have LPC, because at LPC, that's why when you go to LPC and you are challenged on something, or you go to court and you are challenged on something, how about tabutsi, and you concede to say ban tabutsi, you see, because that's why lawyers study hard. And about tabulandadi, they beat you up. Yeah, your colleagues beat you up because you quoted a case law, and some laws are amended and you are not aware of that. They beat you with an amendment of a section that you used, and you thought you will win the case on that section, and you did not consider an amendment of that section, and they beat you there. They beat you on a case law that you did not reference. You did not take the time to study and check if it's available. And once they quote it, they will tell you, no, this is the constitutional law. Judgment. It was the Zuma case. Concord created a problem on a Zuma case. And because of, by principle, once Concord, Constitutional Court, makes a pronouncement, that's the end of the deal. Yeah, they tried it to appeal. They could not win because of, now all that Ngugai told me, I remember, when he was dealing with that case, was to say, but there's a judgment already in the constitutional law that says, I remember even Justice Mutapo was busy trying to argue him, and I could hear that no, Justice Mutapo is doing a valid, but now when Ngugai Toby came in was to tell him, amen, but there was a judgment. They say, no. Okay, fine. Because umthetho umdlile, and he concedes to be beaten by an advocate, a senior counsel, who's not part of the 11 at the Concord there. Because it's the same thing, it's the same practice, same law. Engineers, I heard Umam Kaluva in reaction to that SIU report that is misguided, saying, but engineers come into the country. Hey, why engineers? Mam Kaluva, engineers deal with the same science. There's no electricity for vets and electricity for UCT on engineers. There's no tar road. There's no structures. No, a structure is a structure. A cement is cement for all engineers. Those, is it telescope or what, those scopes that they're using to measure roads width and so on, to check the level if it's okay. They are using same instruments from the same factory in most of the cases. Same things, same instruments. So it's easy to regulate. That's why when they challenge them, they are like, you did not use that instrument correctly. Let's show you how it's used and get it. They concede. And other sciences, the list is exhaustive. But guess religion. You can't write a law for religion, let alone the Christian faith, because Rabola Church is here and is Christian. So if they are on the council, it won't work. Some believe in Amadlozi, you see, and they are Christian. What law are you going to? Because according to the scriptures, I even told CRL then that, guys, your job is heavy, because in the African traditional religion, when a person manifests, they say, ukoko figile. And it's amazing. These days, ukoko figure too early. Children from primary school, they bunk school to attend to Gogo's practices and so on. Because a primary school child, they must bunk school. And according to the law of the country, that's a problem. But who's making noise about that? They are not making noise about it. Hey, ugogo uyambisa. Best, actors, we knew they are actors. And ugogo ambisa from SOP and then gogo ambisa. Will you argue that? You see? But when we see that, we are like, la. Yeah. Mark chapter 16. He says, in my name, you'll drive out demons. And when you come the Mark 16 way and say, Puma demon, they are saying you are judgmental. So we must not say these are demons. We must concede and say, Abokoko, even though we know, according to our faith, these are not Abokoko. They're demons. But for political correctness, we just accept and say, oh, because you like it, Abokoko, do it your way. But once you come in my space where we practice our faith, where we believe, and you say you are sick, and we pray for you, and ugogo aphume, somkhipha ugogo aphume, and then umuntu abe right. Inasmuch as those who are in that space, they believe some of the Christians are in denial of Abogog, and they win the Christians into their belief. You see? There you have it. Why should we be the one who succumb? Who must compromise? When other people, are celebrated for what they are doing and things like that. So family, it's impossible. Section 22 of the Constitution says, the practice may be regulated by law. It's impossible to regulate religious practice by law. This thing was established in 1990 at the Interfaith, what do they call it? The National Interfaith Conference on Religion-State Relations, even before this constitution was crafted. The likes of Dr. Frank Chikane, Rev Chikane, Dr. Yusuf Dadu, they agree with what I'm saying. Dr. Jocelyn Halek, from the Jewish community, Udadu from Islam agrees with me. Reverend Nkosi from Mufukim, from your African traditional religion, they agree with what I'm saying. And that document, those papers they were presenting in that colloquium, they were speaking to these issues as way back as 1990. If you can read, that thing, you will see these are not new things. They conceptualized them before the crafting of the Constitution. So in their crafting of the Constitution, the things I'm talking about are what informed how the Constitution is being written. It's just that our people don't read. They don't study. They don't research matters and find out. I mean, you are talking about Reverend Chikan from AFM, and SACC was talking to what I'm talking about, and is agreeing with what I'm telling you now. Your use of Dadu. I saw a street in Mohali City, Dr. Yusuf Dadu Street, Ikaban. So they agree with this. Abu Jocelyn, Dr. Ginosi, Abu Anil Sukal from the Hindu religion, your Justice Albisaks, former constitutional court lawyer. Most of the ideas he's been sharing them, to assist in these matters, and he's been against this thing that the CRL wants to achieve, and they've been saying since then this is an impossible thing to do because of it will infringe on people's rights of religion and their beliefs and so on. So there should never be a situation where there's a state regulation or the state is forcing other people to practice. The people in that belief, they must determine what must happen in that space. And Umam Kaluva is saying, on that as SIU thing, to say if we had that peer review as we envisioned it, this thing could have not happened. Icon. I took this straight to the head of communication to say, what are you doing? What are you saying? There's nothing like that. Because if that assertion is to be true, then you must say to me, they are talking about 2,000 plus irregular applications that came fraudulently and so on. Tell me that everybody in that list is a so-called prophet or a pastor or a religious person. Some are in business, some are in that. So that deduction is very wrong. It's very wrong. But because CRL wanted media leverage, you see, to ride on the wave. We'll keep on challenging them in parliament and everywhere. And SACD will be having the march there in KZN. So interesting. Other bodies, your anti-regulation of religion, they are having a summit there on the 21st in Alberton there, the Alberton Declaration, and in different corners. And West Part, even the church where Umam Kaluva belong, the Wesleyan Church, they agree with my position. They are saying, the Methodists, they are saying it's impossible to achieve what Umam Kaluva is looking for because of polarization of religion. This thing must be done by people who believe in the same thing wherever they are. And as for other things, those are failures of the state. And next time we have this conversation, I will tell you, because last time in parliament we were challenged that now, but guys, you are raising only problems. You are not telling us about the solutions to this matter. Solutions have been there way back as 2019. We have mapped them, we have located them through my organization, our organization, Council of Charismatic Churches. We have mapped them. They are there, they are available. They are available. So, but next time I'll be sharing to show you, what is it that can be regulated within the church space? What is it that is impossible? And everything that can be regulated in religious space is not specifically for the religious space. It applies, it cuts across every juristic person. Issues about handling of finances. It's not a church thing, fella, or only. It's not a church thing. It cuts across. Handling of finances is expected in all juristic persons on how to deal with finances. Issues of building compliance are expected everywhere where buildings are used. It's not tailored for churches. And those we agree with because they are not meant for the churches. They have nothing to do with our beliefs. They are administrative things. And then those ones are measurable. That's why we can study administration. Administration is the same thing everywhere. What is different is where do you apply it? I mean, administration is generic. Building compliance is generic. All these other things are generic. So that's why we don't have issues with them. But on this one, Yogu Kolwa, of how we believe things, we have a different story. And thank you for your time. I know we have stretched a little bit, but sometimes we have to take the time to unpack these things. Yeah, because sometimes this sound bites. I mean, in parliament last time, I was given 3 minutes for something that I can spend hours on to bring understanding because, in parliament, those are not specialists. They want to hear from us as to what does this mean so that we show them so that, in their writing of laws, they can do the right thing. And sometimes now in the courts, even the courts, I've seen even the courts, even the judiciary, some of these things, especially faith-related things, most of them are ignorant. So there's a problem, of justice, fairness in terms of justice there in the courts. Because how do you adjudicate on matters that you don't understand yourself? Yeah, although judges, work with cases, arguments that are brought by lawyers and so on. But I've seen, that it's important. That's why a judge is an assessor. So as an assessor, you must be a subject matter expert so that in your judgment, you can apply, the principles, fairly and so on. But you can't be a good judge of something that you don't know. Yeah, and most of them, they don't know. Yeah, and they'll be adjudicating on these cases and so on. And I've seen even the church, we die because we lack knowledge. We don't have the time to study these things and find out. And somewhere you'll trick yourself and beat yourself up. All that, Umam Kaluva has been thriving on has been the ignorance of the church. And then why are we where we are? Certain laws were not supposed to have been passed by now because of our ignorance, especially as the church people. So we must do away with ignorance at all levels. And some of us, because we are educators at heart, we have the time to educate. And when you don't know things, please don't speak to them. Ask those of us so that we show you what is it that is happening and so on, because we've been studying these things from where they started and so on, not sound bites from media, this propaganda on media and so on. As for the challenge to challenge the CRL, we wish for a day when ourselves who are anti, and those who are pro this thing can be in one room to discuss these things. Unfortunately, I was talking, Dr. Godu, he was supposed to be somewhere in Joburg tomorrow and engage Dr. Maluma. And then I said, Amen. Yeah, if you make it to that place, I will say indeed. Yeah, the likes of Dr. Maloma really is stirring to feel that heat. Yeah, to engage, because I know they don't like dissenting voices. They would claim to like them. Yeah, but that's why they will invite friends, people who are for them, to come into media, even media houses that are pro them. Tina Sbasabi, bring everybody. We've been to ENCA, we've been to Newsroom, we've been to SABCs and so on, to talk about this thing, radio stations to talk about these things, because as Sabi Muntu, because truth doesn't need to protection. When something is true, let it be there. You don't silence people because of different views and intimidate the likes of SAFM, like how CRL intimidated a journalist. They wrote a script even for that journalist to say, apologize to CRL in this way on your program, because Nkosi was there saying something as if they don't know that Nkosi. They call me somebody who's against Kaluva, wants to remove Kaluva from office and so on. How could SAFM invite such a person and so on? We are ready. Bring the media here. We've been challenged through media. Umam Kaluva has been saying, where are they? I was in Kayalami to say, I'm here. The next thing, she doesn't greet me. So, what's up? Thank you. Hey, I can talk until midnight. Yeah, because I have a lot to say, but in the interest of time and practicality, let me drop the mic here. Thanks for your time. Otherwise, for those of you who are joining here, I see my senior there, Dr. Joe. I see, hey, my pastor there. Hey, Pastor Ntsako, I see you there. Hey, Pastor Josh, I see you there. Yeah, I see you. Mr. Bongwe, I see you there. Hey, Chaplain, I see you there. Hey. I see you, Songwan, I see you there. How's Zizi? I see you there. In my corner somewhere here on the screen, I see you. Thanks for the time. And everybody that I seem not to see here readily on the screen. Yeah, may the Lord richly bless you. I think this will be helpful. And please do share this broadcast, with whoever needs understanding on this matters. Don't be intimidated by people who are just showing up, intimidated just because they are on media. They have the privilege of being in media. Asibasabi. Tell them, Nkosi is ready. Yeah, because we are challenging them personally and so on. Some of them avoid us. Some of them, we do have a conversation and they choose their way. They can't claim ignorance and so on because they know. We've told them from day one on April. Thank you. Otherwise, I won't stop. I thank you for your time. Be blessed.